Okay, let's unpack this for you. Today, we're doing a really exhaustive deep dive into a comprehensive legal review report. And this report concerns the highly complex U.S. proceedings against Mr. Kwok.
Right, and we should be clear, this material goes way beyond your typical financial crime brief.
It really does. The source analysis we're examining today is incredibly detailed, and it argues that this case sits, well, squarely at this really volatile intersection of Sino-U.S. geopolitics, the integrity of U.S. federal institutions, and, fundamental constitutional rights.
What's fascinating here, I think, is the sheer technical ambition of the report itself. It meticulously applies U.S. constitutional law, federal regulations, and very specific case law.
But not just to defend him, right?
Exactly. Not just to defend the client, but to argue that this whole proceeding is one of the most serious examples of what the authors call lawfare in U.S. judicial history.
Lawfare. So that's the weaponization of legal systems to achieve what, political or geopolitical goals?
Precisely. And so our task today is really to analyze why the report claims that these external political pressures may have actually deviated the prosecution from its constitutional obligation, which is to seek justice, toward just, securing a conviction no matter the cost of the process.
That sets a very, very high bar for the analysis. The report promises to demonstrate how these alleged procedural abuses, glaring conflicts of interest, and judicial inconsistencies, and this is in both criminal and bankruptcy courts, have systematically led to this crackdown.
And an effective seizure of the defendant's assets, not to mention the nullification of his rights.
Right. The environment created, according to these authors, has effectively hollowed out the constitutional principle of the presumption of innocence.
Claim
It is. So our mission is to dissect these claims, starting right at the source, the geopolitical claims that really form the foundational argument of the entire report. The review starts by placing this entire legal saga within the macro background of the CCP's global operation known as Operation Fox Hunt. Now, the report really stresses that this isn't just speculative political talk. It's an argument built on legal facts that have been confirmed in separate U.S. federal cases, which gives this whole geopolitical context some real legal weight.
And that weight comes from the external confirmation.
Yeah.
You have cases like United States v. Michel and the George Higginbotham conviction records. This is a critical foundation for their whole argument.
Okay.
The source material establishes that it's a legal fact that high-ranking CCP officials, they specifically cite the former Vice Minister of Public Security, Sun Lijun, met directly with George Higginbotham.
And Higginbotham was, at the time, a DOJ senior congressional affairs specialist.
A serious insider.
That meeting and the conspiracy that followed proved a direct link. The report emphasizes that these CCP officials provided false documents, false intelligence to these DOJ insiders. All of it was an attempt to get the U.S. government to deport Mr. Kwok back to China.
In Higginbotham, a DOJ official, he admitted to his part in this. He admitted to the scheme to illegally influence U.S. government decisions.
This background is so crucial because it sets up what the report calls the tainted origin argument.
It does. If we connect this to the bigger legal picture, the report is applying a variant of a really foundational concept known as the fruit of the poisonous tree doctrine.
Right, which traditionally means that evidence you get illegally, say, from an unconstitutional search, you just can't use it in court.
Exactly.
But here, the report is applying it to the very origin of the entire investigation, not just one piece of evidence. That needs a deeper explanation. How can a conviction in a totally separate case against a former DOJ employee potentially taint this entire current investigation?
Well, the tainted origin argument is potent. The claim is that if the DOJ was being actively targeted for high-level CCP infiltration between 2017 and 2018.
Which is exactly when the CCP was trying to get him deported.
Precisely. So there's substantial reason to infer that the initial financial investigation against Mr. Kwok was actually triggered by CCP disinformation. The report highlights that fabricating detailed evidence of fraud or money laundering. This is a documented tactic. It's what the CCP uses to silence dissidents globally, often using things like Interpol red notices or official legal assistance requests.
So the suggestion is that the initial spark, the reason federal agents even started looking at his finances, was itself compromise. It came from a politically motivated foreign source that was just dressed up to look like a legitimate financial tip.
Exactly right. And the report uses this to build the case for institutional bias. I mean, even though the official involved, Higginbotham, was caught and convicted, the investigation against Mr. Kwok had already picked up a lot of momentum.
And it's hard to stop that train once it's left the station.
It is. The difficulty is in proving that a later prosecution team, even if they're acting in good faith, can fully purge that initial premise. The report suggests the current prosecution team may have um, unconsciously inherited early tainted investigation files.
And what's the implication of inheriting something like that?
It creates a potential institutional bias. Once a target is flagged through a high-level, albeit compromised, intelligence stream, it becomes really hard for prosecutors to view that target impartially.
So instead of seeing him as a political victim, which his asylum status would suggest?
Right. Instead of seeing him as a political victim fighting a hostile state, the report contends the prosecution just sees him as a troublemaker or a high-level fraudster. This loss of impartiality, the report argues, is what drove the shift from a search for justice to this aggressive convict-at-all-costs stance, regardless of any constitutional hurdles.
Okay, so let's tie this directly to what the report claims is the ultimate goal here. The geopolitical context suggests the CCP's strategic objective. It sort of shifted from physical deportation to the economic suffocation of their most significant dissident.
A dissident whose anti-CCP movement relies heavily on continuous financial support.
And that is the core of what the report calls the political prosecution claim.
It is. The report argues that the prosecution's specific legal strategy, which was to characterize all of Mr. Kwok's fundraising activities, so GTV, GCLBS, Himalaya Exchange, all of it, just uniformly labeling it all as Ponzi schemes,
Yeah.
that this is essentially executing a political funding cut.
So by dismantling his financial structures, the U.S. legal process is, maybe unwittingly, achieving the CCP's main strategic goal of just neutralizing his political movement.
That's the argument.
This brings us squarely to the First Amendment conflict analysis. In any U.S. fraud case, and the report references precedents like United States v. O'Hagan, the prosecution has to prove scienter. So for our listeners, what is scienter?
Scienter means fraudulent intent. It's the deliberate knowing intent to deceive investors for your own personal gain. And this is where that political context becomes absolutely paramount.
Because the report is claiming the prosecution just systematically ignored the political purpose behind all the fundraising?
Exactly. The defense theory posits that these ventures were set up precisely to create media and financial platforms that were free from CCP control. It was a matter of political necessity and, frankly, survival.
But, okay, let's play devil's advocate. If the businesses failed or if the funds were mismanaged, how does political intent save the defendant from fraud charges?
That's the million-dollar question. The report argues that if the investors were primarily motivated by political support for his anti-CCP movement, so if they saw their contribution as supporting a cause, kind of like a political donation, then even if the business itself faced high risks or ultimately failed, that failure shouldn't automatically be considered criminal fraud.
I see.
The report really stresses that excluding this essential political background forces the jury to look at what are essentially political transactions through a single lens, financial crime. And that exclusion, therefore, is characterized as a disguised suppression of the defendant's First Amendment rights, freedom of speech, freedom of association, by criminalizing the means through which that speech and association were funded. And the overall complexity just escalates dramatically when we shift our focus to the parallel civil proceedings.
Right. This isn't just happening in one court.
Not at all. We have to look at the involuntary Chapter 11 bankruptcy case, which is in Kwok, overseen by the Connecticut Bankruptcy Court. The report argues that this parallel court system became, well, an active co-conspirator in this lawfare. It raises these deep legal challenges about the role and the alleged illegality of the appointed Chapter 11 trustee, a man named Luke Despins.
And a bankruptcy court is supposed to be this impartial steward, right? Protecting assets for everyone involved, the creditors and the debtor. But the core allegation here is a major disabling conflict of interest surrounding trustee Luke Despins and one specific creditor, PEG, the Pacific Alliance Group.
And the requirement for a trustee is strict impartiality. It's stipulated right in the Bankruptcy Code, 11 U.S.C. Section 327.
Okay, so what does that statute say?
That statute requires the trustee to be a disinterested person. What that means is they can't hold or represent interests that are adverse to the estate or to the general body of creditors. Let's detail the Despins-PAG connection, because it's really the linchpin of this whole part of the report.
Okay.
Luke Despins is a partner at the international law firm Paul Hastings, LLP. The report cites documented evidence that shows Paul Hastings has maintained a long-term economic relationship with PEG.
And what does that relationship look like in practice? Is it just they did one case for them once?
No, not at all. The report highlights that Paul Hastings has consistently represented PEG in various complex corporate transactions. We're talking multi-billion-dollar acquisitions, advisory roles. This is not a casual connection. It's a deep, continuous, and highly profitable client relationship.
And critically, PEG is one of Mr. Kwok's largest and most hostile creditors.
And it was PEG that actively initiated the involuntary bankruptcy proceedings against him in the first place.
The report also brings in that geopolitical element again here, right? Repeating claims that the PEG chairman, Wei Jianshan, has close ties to CCP leadership and that PEG itself has massive investments in mainland China.
Which suggests it may be functioning as a potential proxy for the CCP in this whole action.
Mm.
So you combine all these factors, and the report argues the conflict is just objective and overwhelming. Despins, the Paul Hastings partner, has a clear professional incentive to favor PEG's aggressive legal strategy, which, the report says, aligns with the CCP's goal of asset seizure over the debtor's constitutional rights or the interests of other creditors.
And this violates the standards set by the Second Circuit Court of Appeals.
A very strict standard.
We should explain that standard. The report references cases like Inri Aerochem, which establish that even a potential or apparent conflict is enough. It doesn't have to be a proven actual conflict.
Precisely. The goal is to ensure the integrity of the process itself. A trustee has to be perceived as disinterested. The report argues that Despins' refusal to recuse himself and his immediate launch of these very aggressive adversary proceedings against Mr. Kwok and his related entities, it fundamentally shows a failure to uphold those high standards of impartiality required by Chapter 11.
They claim he basically acted as PAG's legal wing, just with the authority of a court-appointed official.
This alleged conflict then manifested itself in procedural abuses, specifically around the use of default judgments. The report points to the case Despins v. HCHK Technologies, Inc. et al.
Okay, so what happened there?
In that case, bankruptcy judge Julie Manning approved default judgments against several entities related to the defendant. Now, in the Second Circuit, courts usually prefer to resolve disputes on the merits. That means they'll allow a defense if there's any plausible reason for why someone failed to respond to a lawsuit.
And the defense argued that the failure to respond on time was a classic case of excusable neglect. So, for our listeners, what makes this situation excusable?
Well, the report lays out the objective difficulties. At the time, Mr. Kwok was in criminal detention. He was facing severely restricted communication with his lawyers. And at the same time, his legal funds were subject to massive asset freezes.
So he couldn't even hire the right kind of specialized bankruptcy lawyer.
Exactly. These aren't minor logistical issues. They are direct consequences of the parallel criminal case. And the defense was also ready to argue substantive points, that these entities were independently operated businesses, not just shell corporations.
Yet the report claims Judge Manning took an extremely harsh stance, just ignoring all these objective realities.
Yes. The report views this as a deliberate, coordinated action. By denying the motion to vacate the default judgment, the court ignored the objective impossibility of the defendant mounting a full defense under these conditions. It effectively stripped those entities of their right to due process and enabled a very swift asset seizure.
Which, of course, benefited the aggressive creditor, PAG, and the parallel criminal prosecution.
It's all connected, according to the report.
Now, for what the report calls the most devastating procedural claim, the Fifth Amendment trap, or the judicial injustice that arises from having these two cases run at the same time.
This is a textbook example of how this dual system can be, well, weaponized. In the bankruptcy court, trustee Despins repeatedly requested vast financial documents and direct testimony from Mr. Kwok.
About the very same funds and transactions that were at the heart of the criminal indictment.
The very same. Now, under the Fifth Amendment, Mr. Kwok has a constitutional right to refuse to incriminate himself.
And typically, the justice system recognizes this pressure. When you have civil or bankruptcy issues overlapping with criminal matters, courts will usually stay or, temporarily pause the civil proceedings.
Right, to protect the constitutional rights of the defendant.
Yeah.
It prevents the government from using the broader, less restrictive civil discovery process to get around the strict protections that are required for criminal investigations.
But the report notes that Judge Manning refused to stay the proceedings. And critically, she allowed trustee Despins to use Mr. Kwok's invocation of his Fifth Amendment right as an adverse inference in civil judgments.
We need to define adverse inference very clearly for the audience.
Yes, please do.
An adverse inference is basically a court ruling where your silence, the act of invoking a constitutional right, is treated as an admission of guilt for the purposes of the civil case. By refusing to testify or produce documents, the court infers that the reason for your silence is that the testimony or the documents would have been damaging to your case.
That is a catch-22.
It's the ultimate catch-22. The report argues this forced Mr. Kwok into a devastating dilemma. Either he waives his Fifth Amendment right, providing direct, self-incriminating evidence that would lead to a criminal conviction in the SDNY court.
Or he remains silent and just watches as his vast assets are legally confiscated based on the assumption that his silence proves fraud in the bankruptcy court.
The report insists this effectively nullified his constitutional right against self-incrimination, specifically to make it easier to seize his estate. It transforms a constitutional shield into a sword for financial punishment, demonstrating what they call a systemic collapse of procedural justice.
Let's pivot now to the SDNY criminal trial. This was presided over by Judge Annalisa Torres, and we need to examine the claim that limitations imposed here fundamentally deprive the defense of its core theory.
This is where the criminal court's actions allegedly reinforce the political nature of the whole prosecution.
And the most severe limitation, according to the report, was the strict ruling that restricted the testimony of the defense's China expert, Dr. Paul Duran. This ruling, the report argues, it just gutted the defense's ability to provide crucial context to the jury.
So what specifically was he not allowed to talk about?
He was largely barred from testifying on the systematic nature of CCP political persecution, the freezing of Mr. Kwok's global assets, and the operational details of Operation Fox Hunt.
Wow.
He was only allowed to discuss extremely limited, almost non-substantive topics, like the existence of illegal CCP police stations in New York.
So things the jury might have already heard about on the news.
Exactly, and the defense argued this exclusion was fundamentally flawed under the federal rules of evidence.
Let's get into the legal mechanics here. The prosecution would have invoked what, FRE 403, arguing the geopolitical testimony would cause confusion of issues or unfair prejudice.
Right. And the defense argued it was necessary under FRE 702, which is what governs expert testimony.
And this is the core relevance argument. The defense theory hinged entirely on lack of fraudulent intent, on scienter. The complex offshore structures, the use of nominees, the unorthodox financial transfers, all the things the prosecution was calling fraudulent, were allegedly survival mechanisms.
It's designed to evade the CCP's financial strangulation and their ubiquitous asset seizure apparatus.
If the complex structure was a defense mechanism against a hostile state, then it wasn't a mechanism to deceive investors.
Exactly. Duran's testimony was crucial to establish the rationality of unconventional behavior. The expert would have provided the jury with the context that in the high-stakes world of CCP dissidents, unconventional financial moves are rational defenses, not proof of criminal intent.
And the report argues that Judge Torres's ruling under FRE 403 was a severe error.
Why does the report go so far as to say the exclusion guaranteed a conclusion of fraud?
Because by excluding the evidence of the political threat, the court severed the chain of understanding for the jury. It cut off the defendant's logic. The jury was forced to view all these financial operations in a vacuum, applying the standard expectation of typical U.S. business behavior.
And in that vacuum, complex offshore structures and fund movements, they naturally look suspicious.
They look incredibly suspicious. It almost inevitably leads to a conclusion of money laundering or criminal fraud. The report concludes that this exclusion deprived the defendant of his constitutional right to present a full and meaningful theory of defense.
Let's move to another crucial constitutional protection, the denial of bail. The report strongly challenges the court's finding of a high flight risk, calling it a profound misapplication of the Bail Reform Act.
This is where we get the paradox of flight logic. I mean, Mr. Kwok is a very high-profile target of a hostile foreign power. The report contends that fleeing the U.S. wouldn't lead him to safety. It would immediately expose him to life-threatening danger or deportation back to China, where he's the CCP's most wanted individual.
So the flight risk claim, according to the report, is logically absurd when you look at the geopolitical reality of his situation. His only refuge, his only path to justice, is actually winning his case right here in the U.S. court system.
And the report highlights the very stringent conditions the defense offered.
It was an extraordinary proposal. It included posting tens of millions in bond, relinquishing his passports, submitting to extreme electronic monitoring,
and even funding 24-hour armed private security monitoring.
The fact that the court denied even that maximum level of restriction, the report argues, suggests a preset presumption of guilt. So, pretrial detention in this context is viewed by the report not as a necessary protective measure, but as a punitive one.
Right, used to paralyze the defendant's ability to coordinate his defense and manage any remaining resources he might have.
Finally, under this section, we have to address the internal email that the report flags. This is where prosecution team members discussing alleged Brady violation challenges use the phrase, "We're going to smash these guys."
Oof. Yeah, that internal communication is flagged as a major warning sign regarding prosecutorial objectivity. Under Brady v. Maryland, prosecutors are held to the standard of ministers of justice. Their primary duty is not to win at all costs, but to ensure justice is done, which includes disclosing all exculpatory evidence.
So the report argues that this smash these guys mentality suggests it's a systemic loss of impartiality and objective detachment.
It does. And what are the procedural implications of that mentality, beyond just a bad choice of words?
Well, the report warns that this mindset correlates with several adverse procedural actions. First, the potential withholding of Brady material.
The exculpatory evidence.
Right. Second, overcharging the case, like escalating a dispute to a complex R2 offense when simpler fraud charges might have been enough, just to increase punitive pressure.
Yeah.
And third, using asset freezes and bail denials specifically to undermine the defendant's ability to mount an effective defense.
So it transforms the prosecution from an impartial representative of the state into an aggressive political adversary.
We move now to the human element, the witnesses. And this is where the report dissects the motives and the statements of key players, arguing that the integrity of the testimony supporting this central charge of fraudulent intent of scienter is critically compromised.
And the cornerstone of the prosecution's scienter charge, it really rested on the testimony of Yvette Wang. She was Mr. Kwok's former core assistant. She pleaded guilty, received a 10-year sentence. And the report identifies several factors that really undermine her credibility.
The first factor is the powerful incentive she had to cooperate, which the report labels the lure of the 5K 1.1 motion.
Exactly. A 5K 1.1 motion allows the prosecution to ask the judge for a downward departure from sentencing guidelines in exchange for substantial assistance. Wang was facing potentially decades in prison, so to get that reduction, she had an overwhelming, life-altering motive to fully conform her narrative to the prosecution's version of events.
And to place the entirety of the responsibility for all alleged financial wrongdoing onto Mr. Kwok.
Completely. The report asserts this intense pressure makes her testimony inherently suspect.
Furthermore, the report claims her testimony was just riddled with contradictory statements.
Yeah, an analysis of the court records, according to the report, it reveals these fundamental differences between her initial explanations of the fund flows, the one she made when she was a loyal employee managing the accounts, and her later testimony given as a cooperating witness.
Can you give an example?
Sure. Regarding the Himalaya exchange, she initially had recorded communications stating the funds were safe and reserved. Later, under the pressure of the 5K 1.1, she testified under oath that the entire operation was a Ponzi scheme orchestrated by Mr. Kwok.
That is a radical shift in characterization. It definitely raises serious doubts about the reliability of her testimony.
And finally, the report points to the critical lack of corroboration.
So no paper trail.
Very little. Many of the crucial charges regarding Mr. Kwok's personal intent rely solely on Wang's account of his oral instructions. There's often an absence of written instructions, third-party emails, or objective financial records that independently verify her claims about his intent to defraud.
So the report concludes that if the prosecution's whole case hinges on the credibility of one highly incentivized witness, then the scienter charge lacks the objective proof required for a complex financial conspiracy.
The report then raises a really explosive claim regarding the alleged victim testimony, like the testimony provided by Jenny Lai. It argues that any analysis of it has to account for potential CCP manipulation through its united front work.
And this is the allegation of potential CCP manipulation, which links back directly to that tainted origin argument we talked about earlier.
Right. The United Front is the CCP's mechanism for influencing non-communist groups and individuals abroad. The report suggests there's evidence indicating that the CCP allegedly organized and coached individuals to pose as victim investors and then file false complaints with U.S. agencies like the FBI and the SEC.
And the purpose would be twofold: to provide the prosecution with a compelling victim narrative and to inflate the scale of the alleged fraud.
And this manipulation claim connects right back to the evidentiary restrictions we discussed. The report notes the missing cross-examination opportunities.
Precisely. The defense was unable to effectively challenge the credibility of these supposed victims. They tried to ask crucial questions. For instance, were these witnesses under threat from the CCP? Were their families in China contacted or threatened?
And the report states that because Judge Torres had severely restricted the China expert Doran's testimony, the prosecution successfully objected to these questions as irrelevant or speculative.
Which prevented the jury from assessing this powerful geopolitical motive for perjury or for filing false complaints. It shielded the witnesses' true motivations from any scrutiny.
The final aspect of this credibility crisis relates to the absent co-defendant, William J. He was the CFO, and he's currently a fugitive.
Right. And Jie, as the CFO, was the individual who actually executed many of these complex financial transactions. His absence creates what the report calls the attribution problem. The report notes the prosecution uses his absence to its utmost advantage. They simplify the complex financial web by just attributing all the irregular or allegedly illegal actions that were operated by Jie directly to Mr. Kwok's instructions.
And the defense, because they don't have Jen's testimony, is unable to prove that certain irregular operations were Jie's own unauthorized actions, his frolic and detour, as they say, or maybe just technical errors, rather than specific fraudulent instructions issued by Mr. Kwok.
So his absence becomes this powerful, unchallengeable piece of circumstantial evidence for the prosecution, and it removes a key source of potentially exculpatory evidence for the defense.
We have to now turn to one of the report's most compelling structural arguments, and that's the claim of judicial double standards, which they get to by comparing this case with the very high-profile SEC v. Ripple Labs litigation.
Both cases involved digital assets and, critically, were presided over by the same judge, Judge Annalisa Torres.
And the report argues that analyzing the two rulings side by side reveals a substantial inconsistency in how legal standards were applied.
For our listeners, we should probably start by explaining the legal framework for these decisions. Both cases hinged on whether the digital assets were classified as securities under U.S. law, which is determined by the Howey test. Can you quickly break that down for us?
Absolutely. The Howey test is a four-pronged Supreme Court standard. It requires proving 1. An investment of money, 2. In a common enterprise, 3. With the expectation of profits, and 4. To be derived solely from the efforts of others like the promoter or a third party. If you meet all four prongs, it's a security.
Okay, so with that in mind, let's look at the inconsistency in Judge Torres's rulings across the two cases. Let's start with the treatment of secondary market sales of these digital assets. H-coin and G-coins versus XRP.
Okay. In the Ripple case, Judge Torres ruled that programmatic sales of XRP on secondary exchanges, so sales to retail investors who were buying from a third party, not directly from Ripple, were not security offerings.
And she made a technical distinction to get there.
A very technical distinction. She ruled that the investors in the secondary market did not rely on Ripple's organizational efforts because they bought blind on an exchange for speculative purposes. This distinction, which is based on the fourth prong of the Howey test, was crucial, and it signaled a very measured, nuanced approach to digital assets.
So how does the report claim she treated the Kwok case differently?
Well, the report argues that in the Kwok case, Judge Torres ruled the sales H-coin, G-coin, uniformly as fraud and unregistered securities without applying that same crucial distinction between primary and secondary market sales.
So no nuance?
No nuance. The report suggests the court accepted this crude, generalized characterization that crypto is a scam tool and neglected to apply the nuanced legal framework she had utilized in the Ripple ruling just months before. This is what they allege is proof of an arbitrary judicial double standard.
The second dimension here is investor perception, how the judge viewed the motivation of the investors themselves.
Right. In Ripple, the judge acknowledged that retail investors were relying on market speculation and the movement of the cryptocurrency market itself. But in the Kwok case, the report claims the judge ruled that investors were completely and solely deceived by Mr. Kwok, entirely ignoring the political support aspect.
We talked about that earlier. The report argues the Kwok investors are more accurately viewed as political donors, people who invested because they supported the anti-CCP cause and were seeking a political platform, not just a financial return.
And their expectation of profit was intertwined with that political outcome, yet this subjective motive was allegedly ignored, which basically guaranteed a finding of fraud.
The practical result comparison, according to the report, makes this double standard just undeniable.
Well, the Ripple case resulted in a partial market-shifting victory for the company. It preserved the firm and led to a major stock surge.
And conversely, Mr. Kwok is facing full conviction and total asset seizure.
The report concludes that this stark, outcome-oriented difference can't be explained by objective legal facts alone. It strongly suggests a preset bias against Mr. Kwok, where the judicial standard applied was significantly harsher, arguably denying him equal protection under the law.
Beyond this horizontal comparison of rulings, the report also argues that the bankruptcy court under Judge Manning and the district court under Judge Torres formed a kind of functional pincer movement, coordinating to deny the defendant his rights.
And this coordination is identified as leading to two major systemic abuses. The first is the abuse of discovery. The criminal prosecution, which is constrained by the strictures of the Fourth Amendment regarding searches and seizures, allegedly used Trustee Despin's broad discovery powers in the bankruptcy court as an end run.
Can you explain the difference in those discovery powers?
Sure. Rule 2004 of the Federal Rules of Bankruptcy Procedure. It grants trustees extremely broad, almost limitless power to examine a debtor's finances and activities. It far exceeds the restrictions placed on criminal discovery, which requires things like probable cause, specific warrants, and strict chain of custody rules. So the prosecution effectively outsourced their discovery needs to Despins, getting vast financial information without any constitutional oversight.
The bankruptcy court acted as the prosecution's constitutionally exempt backdoor into the defendant's most sensitive financial records. That's the report's claim.
And the second abuse.
The second abuse is the coordination on asset freezes. We come back to this circular logic we've seen before. The criminal court denied bail, citing unclear assets, and the difficulty of ensuring funds weren't transferred out of the jurisdiction.
But the assets were unclear and unavailable precisely because the bankruptcy court, through Trustee Despins and Judge Manning, had imposed a total freeze and takeover.
It's a self-fulfilling prophecy. So, the bankruptcy freeze prevented the criminal court from seeing the assets clearly enough to approve bail, which in turn guaranteed pretrial detention.
Exactly. The defendant was punished with detention based on a lack of clarity that was manufactured by the simultaneous actions of these separate but coordinated judicial processes. The report concludes this systemic coordination shows the legal system was acting as a single, unified mechanism against the defendant's freedom and property.
And this is where the report synthesizes all of its findings. It concludes that this case represents the demise of procedural justice through lawfare. The source material argues that the influence of a foreign power has functionally transformed U.S. judicial proceedings.
The report argues this case exhibits textbook third-party intervention characteristics. It points to long-term intelligence preparation, specifically citing pre-investigation reporting to U.S. regulators.
It points to documented personnel infiltration, which the Higginbotham case legally confirms.
And external non-legal pressure, like orchestrated protests. The overarching conclusion is that the CCP allegedly transformed the U.S. judicial system into a tool for political repression. It achieved a form of unrestricted warfare right here within U.S. borders by turning civil and criminal courts into instruments of asset stripping and political silencing.
Given the gravity of those claims, the report concludes with very strong recommendations about the necessity of constitutional supervision over the actors involved.
The report argues that the conduct of all parties, prosecutors, and judges must be subject to continuous constitutional-level scrutiny. For the prosecution, the focus has to be on whether they concealed Brady material or if they actively ignored verifiable clues of CCP interference with witnesses, including that organized victim testimony.
The report insists the public and appellate courts require proof that the prosecution genuinely sought justice and not just a political victory.
And what specific questions does the report raise about the judge's conduct?
It explicitly questions if Judge Torres's rulings were influenced by geopolitical considerations, heavy media coverage, or pressure from the Department of Justice regarding such a high-profile case.
And crucially, the report questions whether that massive double standard we saw between the strict exclusion of the Doran testimony and the definitive ruling in the Ripple case, whether that constitutes a substantial and reversible error that must be addressed on appeal.
It argues that the failure to provide a rational, consistent legal explanation for treating identical digital asset sales so differently demonstrates systemic judicial bias.
So, to summarize the core conclusions of this comprehensive legal review report, the authors reach four main points after their exhaustive analysis.
First, damage procedural justice. The prosecution, due to institutional bias and this convict-at-all-costs mentality, lacked the required constitutional neutrality. It compromised its foundational role as a minister of justice.
Second, doubtful judicial fairness. The alleged bias in key evidentiary rulings, like the exclusion of Duran's political context and ignoring the trustee's conflicts of interest, it all severely prejudiced the defendant and harmed his right to a fair trial.
Third, substantial impact of CCP infiltration. The investigation may indeed be built on the fruit of the poisonous tree. The initial tainted origin of the investigation, due to that verified CCP infiltration of the DOJ, was never properly cleared or mitigated in the later criminal proceedings.
And fourth, a hollow presumption of innocence. The combined coordinated actions, the denial of bail, the aggressive pretrial asset forfeiture orchestrated through the bankruptcy court, the use of the Fifth Amendment trap, it all amounted to a social and economic execution of the defendant before any final legal conviction was ever finalized.
Which undermines the sanctity of the U.S. legal system's most sacred principle.
And based on this comprehensive foundation, the report outlines specific recommendations for appeal. The focus is very strategic. They recommend filing a Rule 33 motion, arguing for a new trial based on Brady violations, compelling the disclosure of all DOJ CCP communications related to Mr. Kwok to definitively expose any political motives.
And what other challenges do they recommend?
They advocate for a direct challenge to judicial bias, using the Ripple judgment as irrefutable evidence of the judge's inconsistency in applying legal standards. They also recommend an immediate bankruptcy conflict appeal to challenge Despin's trustee status at the appellate level, arguing the conflict was just too severe and too apparent to be ignored.
And finally, a Sixth Amendment challenge focusing on the right to present a full defense and effective assistance of counsel, specifically targeting the wrongful exclusion of Dr. Duran's testimony. This deep dive has allowed us to review a comprehensive legal document arguing that what appears on the surface to be a complex financial fraud case is, well, beneath the surface, a political prosecution that's riddled with constitutional issues and foreign influence. We've analyzed claims of compromised origins, procedural traps, inconsistent judicial standards, and systemic judicial coordination.
Which raises an important question that extends far beyond this specific case. When the geopolitical stakes involve a hostile foreign power actively attempting to weaponize legal systems, and when parallel courts, criminal and bankruptcy, appear to be acting in concert to freeze assets and deny fundamental constitutional protections, how effective can the principle of presumption of innocence truly be for high-profile political dissidents?
The report itself emphasizes that, legally, all charges must be viewed under the presumption of innocence until the final judicial process confirms them. But for you, the listener, the essential knowledge nugget here is the mechanism of lawfare and how it operates, how it transforms the tools of justice into instruments of geopolitical power, successfully blurring the lines between legitimate political dissent and financial crime. That's something profound to mull over as you consider the intersection of finance, politics, and justice in the 21st century. Thank you for joining us for this deep dive.